Members of Parliament, support staff, radio listeners, TV viewers, all those following via social media, members of the media, ladies and gentlemen, good morning. I welcome all of you to the continuation of this public meeting of Parliament. This is public meeting number 5 for today, Thursday, January the 8th. I would like to give a special welcome to the Minister of Finance, Ms. Marinka Gums, and her support staff. We have established a quorum of 11 members. I invite you to stand for a moment of silence. Thank you. I have received notice of absence from the member Peterson, notice of lateness from the member Ottley, and thus, before going over to ask for notifications from the floor of Parliament, allow me to take this opportunity, the first meeting of Parliament for this new year, 2026, to extend on behalf of the Parliament and staff of St. Maarten, the staff of Parliament, the members of Parliament, and all involved with our parliamentary work, best wishes for a prosperous, safe, and healthy 2026. May God bless our country this year. May we be spared of any disasters, man-made or natural, and may we continue the growth and development of our country together. Happy New Year. Happy, prosperous 2026. I now ask the members of Parliament if there are any notifications from the floor, and I see that this is indeed the case as I give MP Lewis the floor. MP Lewis, you have the floor.
Good morning, Madam Chair, Griffier, Honorable Minister of Finance and your support staff, guests in the tribune, my honorable colleagues here in Parliament, and most of all, the people of St. Maarten listening via live stream or on radio. Happy and prosperous New Year to you all. Madam Chair, through you, I would like to make the following statement to the Minister of Finance. As we know, the budget will be presented and debated here soon in Parliament. I will say this: I will be studying the budget thoroughly, because as per right now, I cannot support a budget when the people's money is being spent irresponsibly. In saying so, I mean, up to yesterday, I was in traffic in Coal Bay, and when I turned my head to the left side of the street, a police station that was recently inaugurated had hurricane shutters shut down. Minister, I understood as well that this building cost about $10,000+ per month. If budget needs to be cut, I would say the justice budget shouldn't be touched. But if there is irresponsible spending within the Ministry of Justice, such as those things that I'm seeing, then it needs to be done. While this money can be put for the betterment of the employees or for other stuff within the Justice Ministry. Thank you, Madam Chair.
Thank you, MP Lewis, for that notification. I continue with the members of Parliament making use of notifications, and I give the floor to MP Myers for his notifications. MP Myers.
Good morning, Madam Chair, and to my colleagues here in Parliament, to the Honourable Minister of Finance, and to the greater St. Maarten population at large. I would like to wish each and every one a bright and prosperous 2026 on behalf of the SAM faction, also to the Griffier and all the parliamentary staff as you so eloquently stated in your address, Madam Chair. I wish that God gives us the fortitude and the strength to push forward even in the difficult days. There is no year that we've ever encountered that we've never faced our challenges, but we could only pray that we receive the strength from the Almighty to be able to face those challenges. On a sad note, I would also like to extend my condolences to the family of Hamilton Richardson, who passed away. Hamilton Richardson was the director of the Rahul Lilith Sports Complex. I had the privilege of working alongside him when I was Commissioner of Sports back in the day. And I would like to wish his family strength and comfort during this difficult time. I also would like to extend condolences to the Froston family in the passing of Don Froston. And Don Froston is known in the community for doing his musical renditions at funeral services. He passed away, and I would like to extend my condolences on behalf of my family and my faction to the Froston family. Thank you, Madam Chair.
Thank you, MP Myers. I continue, and I give the floor to MP Lacroes. MP Lacroes, you have the floor.
A blessed morning, Madam Chair Lady, Griffier, Minister of Finance, your support staff, my fellow colleagues, those in the Tribune, and all those listening and looking on social media. Madam Chair Lady, on behalf of the United People's Party and my family, I would like to wish each and every one on St. Maarten, those off of St. Maarten, a Happy New Year, as this is our first meeting. I wish them health, love, money, prosperity, and most important, Madam Chair Lady, strength going out to all those that have family and friends living here and away from Venezuela. And Madam Chair Lady, my condolences go out to the family of the late Mr. Hamilton. His sons were friends of mine, went to school together, so strength on to that family. And Madam Chair Lady, I am looking keen at what the plan is from this government on what was requested concerning the meeting that MP Ottley, MP Lyndon Lewis, and myself requested, because the people want to know what is government's plan moving forward. Thank you, Madam Chair Lady.
Thank you, MP Lacroes, and I continue with the members of Parliament during this round of notifications, and I give the floor to MP Roseburg. MP Roseburg, you have the floor.
Thank you, Chair Lady. A blessed morning to my dear colleagues present here today, to the Minister of Finance and her support staff, Secretary General, Parliament staff, the Public Tribune, and of course to all the people of St. Maarten. My colleagues, previous speakers said it already. I also want to, on behalf of the URSM faction, start off by wishing the people of St. Maarten a happy and prosperous New Year, seeing that this is our first meeting. May this year be one of growth, stability, and opportunity felt for all the people of St. Maarten. And I will also like to take the opportunity to congratulate Mr. Junior Rolock Sr., who at the age of 70, and I believe it was even his birthday, earned his doctorate in political leadership, governance, and social economic development. And I believe that this shows that age is just a number, and that your dreams, you can still achieve them. So, as my grandmother used to say, dream, believe, and achieve. Thank you, Madam Chair.
Thank you, MP Roseburg. The next MP to speak is MP Doran, to whom I give the floor at this time. MP Doran.
Thank you, Madam Chair Lady. Blessed morning to you, my colleagues, the Honorable Minister, his support staff, and everyone that is tuned in under the sound of my voice. Madam Chair, I would like to start by wishing my people a happy, a healthy, and prosperous 2026. I know that 2025 has been quite a challenge for some of us and opportunities for others, but nevertheless, I look forward to growth, stability, and progress for our country on behalf of the National Alliance family. Madam Chair, I would also like to send out condolences to the family and friends of the late Don Froston, who was a pillar in our community, especially as my colleague mentioned, when it comes to different funerals and different events and playing and giving all his renditions and volunteer. Madam Chair, it goes to show that we could be here today and gone today. So therefore, it's all about the legacy, especially us as leaders, as what we leave behind here in our roles, in whatever capacity that we are able to execute. With that being said, Madam Chair, my message to you, or my wish to you, is that we're able to carry on the work of the people. I know last year I made it a point to highlight the fact that a lot of meetings, a lot of requests, a lot of things go unanswered when it comes to this government. And as you mentioned, you represent Parliament, and you represent Parliament in order to make sure that the work of the people gets done once we as members of Parliament put them in. So therefore, again, I would like to reiterate that the meetings that we request get called. We have a very urgent meeting when it comes to the economic development of St. Maarten, which we requested some weeks ago. With the most recent Venezuela situation taking place, we know that we are indirectly impacted by this. So therefore, I hope that is not just seen as something that is pushed under the rug, and we get to handle the people's business. Thank you for the opportunity, and God bless the people of St. Maarten.
Thank you, MP Doran, for your notification, and I can go for notifications.
Good morning, Madam Chair, Kafir, members of Parliament, the Honourable Minister of Finance and her support staff, and to the people of St. Maarten. Madam Chair, I'd like to also wish my family much strength on the passing of my last living grandfather, and also to those who passed away on New Year's Eve, but also to anyone that's grieving any loss or currently for the last few years. Madam Chair, I would also like to mention that I understood that the Minister of VSA and his Chief of Staff is not allowed to enter the building of government. And I think that if that is true, I would even like to pause them for 10 minutes, as you've done in the past when we had urgent discussions, to find out why. Because if a minister and a chief of staff is not allowed to enter the building for security reasons or whatever, I believe as members of Parliament, we should be updated on this urgently. I don't think that's a not serious matter. I even understood that police is supposed to be called in if they do enter the building. So I believe as a coalition, I'm actually very disappointed that we didn't start off the meeting with a notification from government on this, right? And I'm hoping that before we continue this meeting, that we get an urgent response on this matter. In addition to that, Madam Chair, I believe, every January 1st, I try to do a deep reflection on the previous years. I also do a budget analysis on myself, etc. And I don't watch most stories, but I happen to be going through a story, and I happen to be going through your own, and your own mentioned reflection meets resolve. And I like that, and I was very inspired by that, because that means there's a turning point in decision-making and mindset. And I really, really do hope that in Parliament, and even through you, Madam Chair, who I consider one of the leaders of the coalition, one of the leaders in public administration, that we really, really, really see a little bit, or actually I'll say a lot more accountability from yourself and other leaders of the coalition when it comes to the government and how they operate. Madam Chair, and I would say, and partially based on your guidance, we are now going into unprecedented times in terms of how the budget is being handled. Your silence, and I would even say absence, in terms of discussions on the budget, as I said before in other meetings, you have been very vocal when any other minister, including your own, even when Perry Halens was there as minister, on the lateness of a budget. But now, with your guidance, instructing the Minister of Finance prior, saying, hey, if the budget is late, notify Parliament and come with a budget amendment to fix the payments that were made illegally, unconstitutionally by the government. We as Parliament, based on the Constitution, we decide and we approve a budget. The government cannot unilaterally decide they're going to spend money without the approval of Parliament. And I'm pretty sure the Audit Chamber, Integrity Chamber, everybody else is listening to any Council of Advice. I'm really, really interested in knowing the advice from the Council of Advice on the budget amendment coming forward. Because I don't understand how we're going to retroactively in 2026 approve payments that were made in 2025. In addition to that, I also want to say, going to MP Myers with his Minister of Justice, because I appreciate the videos and the reels, And I understand the minister saying, hey, we want to follow a legitimate legal process, right, to be able to pay the justice workers. I saw an article come out from the union leader of the NRPB. I would ask the NRPB leader, union leader, to do deeper queries and search deeper for answers, because you can't on one end say, I cannot pay the justice workers because of legal matters. The budget was approved in June 2024. We paid vacation pay, among others. Right now, persons are being paid other things without a budget approved. So why can't the justice workers get paid too? You can't selectively choose who you want to pay and don't follow the law. Madam Chair, including MP Doran mentioned, meetings being installed. Right now, we have a meeting for tomorrow scheduled. Again, Parliament is being full. We're getting an update. It's tentative. The Minister of TF is not even an island. She's not even an island. Can the Minister of Government say, hey, the Minister isn't here, so let's cancel the meeting for tomorrow? It's not that, it's a secret. So why, again, I'll go back to what you said and end with this. Reflection, according to your words, Madam Chair, reflection meets resolve, and I hope that it's actually implemented this year. Thank you.
Thank you, MP Irion, for your notifications. A lot of matters have been touched on during your notifications. Allow me to respond to some of them briefly. In the proposed protocol between the Prime Minister / the COM and the Parliament, I believe that the Parliament should be informed of the absence of ministers. Right now, the absence of members of Parliament is indicated to the governor. The absence of ministers is indicated to the governor. And the governor indicates his absence to Parliament. So I think to complete that circle rather, it would be right just for us to know of the absence of ministers. We always, in requesting the presence of ministers in meetings of Parliament, we would ask that if the minister is not able to attend his or herself, that then the deputy / substitute minister would then come to Parliament. However, over the years, that has not really been very effectively done. And so it would be good for us to know in advance when ministers are not here, rather than to go through and send official requests only to hear the minister cannot be at the meeting. Point one. Secondly, I have a draft document to be sent to the Minister of Finance regarding the budget or the amended budget 2025. And yes, indeed, I do not believe that in 2026 or even late 2025, we should be talking about an amended budget. We can't have budgetary discussions for a year that has passed. This fact has not only been recognized by myself, it has also been recognized for years in, for example, the Netherlands, where discussions on a budget after the year has been closed is more to finalize whatever issues were not in the budget and not to have a budgetary discussion. A budget is all about predictions. In the case of a budget amendment, after the year is closed, one cannot speak about amendments. And I want that to be very clear in terms of the budget 2025. I want to get that procedure over with the information from government as to whatever changes, whether it's additions or reductions in the budget, for that to be presented to Parliament. Parliament must know about them, but not to have a discussion as if we're discussing a budget. And I want that to happen as soon as possible so that we can get into a discussion about the budget for 2026. That letter, of course, when sent, will be shared with all members of Parliament. And to the Member of Parliament, Irion, thank you for imagining along with me how we all can contribute to one, starting in here, a more effective Parliament, and secondly, a more prosperous and, in my opinion, improved St. Maarten. Everybody has a role to play. I want to stand still for a moment. It has been mentioned by several factions and members of Parliament at the passing, indeed, of the late Hamilton Richardson. And what do I want to add now? Let us own, even in his passing, the late Mr. Hamilton Richardson. I don't know how aware everyone is, I'm sure MP Myers is, of the contribution that Mr. Richardson made. We have seen him here on St. Martin. We have seen him play baseball, but he has left a mark in the Netherlands in terms of baseball. And I want us to recognize that and own him as St. Martin, even in his passing, and give all due to his memory. And the matter of the meeting with respect to the geopolitical situation in the Caribbean, as a member of Parliament, I have directed a letter to the Prime Minister to make sure that the Prime Minister, in his discussions with counterparts, especially those responsible for defense and foreign affairs, the ministers of the Netherlands responsible for those areas, to make sure that St. Martin's interests are also taken into consideration. Yes, we might not be in the direct epicenter of what is taking place, but we are affected just as much as the other parts of the Dutch Caribbean when it comes to these kind of matters. And the last couple of days has been very clear where that is concerned. Today, coincidentally, this matter is being discussed in the Netherlands, in the chamber, with respect to the meeting requested here by members of Parliament. The Prime Minister has suggested, and I mentioned in first instance, to come and brief Parliament behind closed doors. This meeting has been scheduled. However, that does not take away from the request by members of Parliament, which would then be further explained by the Prime Minister, for a public meeting where the Prime Minister can also inform the public in as much as information can be made public. So that consideration is also being given by the scheduling of these meetings. I see MP Irion requesting the floor again. However, at this time, MP Irion, I'll close off notifications. And we don't have a point of order, as you know. Do you have a proposal, MP? I will allow you in notifications, albeit it is not right in notifications, but I'll allow you to make your proposal of order. MP Irion, your proposal of order which has to regard the handling of the agenda point. Before I give you the floor, I forgot to respond to your request pertaining to what you understood to be the case at the government building. And yes, MP Irion, I shall just briefly adjourn this meeting. Let us understand if there's any truth to what you understood to be the case. We'll get to the bottom of that. MP Irion, I guess this would have been your proposal of order. So with that, my apologies. I overlooked that statement because I wanted to say that, yes, I'll give ourselves a few minutes just to understand if such a matter is taking place. So this meeting is hereby adjourned just for 5 minutes. Bear with me, ladies and gentlemen. We shall come back and let you know if there's any credibility to what the MP, that being MP Irion, has understood to be the case at a government building. This meeting is hereby adjourned for 5 minutes. Meeting adjourned. Members of Parliament, ladies and gentlemen, I welcome you back to this public meeting of Parliament. We were still at notifications in this meeting when a question, a concern was posted or mentioned by MP Irion regarding an incident at the government building. It was felt or indicated that certain persons were denied entrance to the administration building. The request was for a brief adjournment, which I gave, and having the Minister of Finance here present, I directed myself to her in terms of what the facts were in this particular case. I heard from the Minister of Finance and also subsequently received a quick phone call from the Prime Minister, who I have asked to put this matter in a brief to Parliament. However, no minister has been denied access to the government building. It has to do with a member of staff of the Minister of VSA that, based on whatever information which the Prime Minister hopefully will elucidate in his writing to Parliament, which I have asked him to do, why a member of the staff of the Cabinet of the Minister of VSA has been denied access to the administration building. So, members of Parliament, ladies and gentlemen, the details we are awaiting from the Prime Minister, but that is the situation right now. I want to thank MP Irion for raising it, because indeed it's important for us to know the correct information, what happened, and I want to, the Prime Minister has asked me to emphasize that it does not regard the minister or any minister having been denied access to the government building. Members of Parliament, I want to thank you for your notifications and discussions, and I go over to the agenda point for this public meeting. And the agenda point is deliberations on the issues surrounding the Central Bank of Curacao and St. Maarten. Those issues were then specified to be as follows: the recent, at the time, nomination of the chairman of the CBCS by the Council of Ministers. A next issue was an update on the ENNIA situation. And thirdly, developments concerning Mullet Bay. The request for this meeting is dated September the 22nd of last year, and it is IS number 092 of the current parliamentary year. The meeting was requested by the MPs Doran, Irion, York, Ottley, and Lacroes. Just a brief mention again before we go over to the agenda point. As this is a public meeting, I will allow the usage of interruptions during this meeting in accordance with Article 43 of the Rules of Order. Again, I emphasize that these interruptions should aim to seek clarification, challenge assertions, or contribute additional information, and should always consist of brief remarks. The members will be allowed 3 interruptions per agenda point, and this is only one agenda point in this meeting. I mentioned that the letter was received from the members of Parliament mentioned. So today's meeting is a continuation of the meeting which was convened on the 5th of November of last year, and after a presentation by the Minister of Finance in accordance with the speakers list, members of Parliament were given the opportunity to pose questions to the Minister in the first round, and the meeting was then adjourned to allow the Minister time to prepare the answers to the questions posed by the members of Parliament. So today, the Minister of Finance, Ms. Marinka Gomes, has returned to Parliament to provide the answers to the questions posed by members of Parliament. And I now give the floor to the Honorable Minister of Finance, Ms. Gums, to answer the questions posed by the members of Parliament in the first round of this meeting. Minister of Finance, you have the floor.
Madam Chair, honorable members of Parliament, Griffier, guests in the public tribune, my dedicated staff, residents of our beloved island, all under the sound of my voice, good morning, a happy, healthy, and prosperous new year to all. Permit me to begin, Madam Chair, by expressing my sincere appreciation to all members of Parliament for their questions, all of which I will address. For clarity and efficiency, I have grouped the questions into 3 categories. Category 1, those related to the Central Bank of Curacao and St. Maarten, particularly to the procedure for appointing members to its Supervisory Board of Directors, especially its chairperson. 2, questions related to ENNIA, and 3, questions related to Mullet Bay. Madam Chair, I will begin with the first category related to the CBCS with questions posed by the Honorable MP York. Madam Chair, MP York asked for clarification on my reference to a political firestorm at the start of my presentation. Madam Chair, by political firestorm, I was referring to the media campaign which several persons embarked upon immediately after the conditional nomination was approved by the COM, and incorrect information pertaining to this decision was leaked to the press and made public. Next question. Did the Central Bank's Supervisory Board share the candidates it identified in its letter dated 21st of January 2025, or has the Minister never received them? Through you, Madam Chair, no candidates were shared. I believe the Honourable Member of Parliament is referring to the SBOD letter dated January 31st, 2025. That letter did not include a list of candidates. It merely informed me, and as it was also shared with all members of Parliament, that the SBOD had identified a strong pool of candidates for the chairperson and intended to proceed with interviews in the near term. However, at the time I proceeded with the conditional nomination in August 2025, no candidates had been provided, nor had any updates been received from the SBOD. To date, nearly 1 year later, no further information has been shared, and I am therefore not aware whether any interviews have been conducted since January last year, but to date, no name for chairperson has been provided. As Minister of Finance, I felt it was important to take the initiative. St. Maarten has waited too long for Curacao to decide the way forward, and with our chairmanship, it was time to show that we're not junior partners in this monetary union, but equal players. Next question. Did the advice leading to the conditional nominee go through the proper steps? For example, legal affairs before reaching the Council of Ministers. Through you, Madam Chair, the nomination process for the chair of the SBOD, as stipulated in the Central Bank's charter, does not constitute an advice that must be reviewed by legal affairs. It is not a legislative matter, and as such, does not require advice from legal affairs. In addition, for clarity, such as an advice conditional does not require submission to the Council of Ministers. However, out of respect for the Council of Ministers, I deemed it important that they were informed of and agree with the proposed nominee prior to my engaging in discussions with my counterparts in Curacao, so as to not to proceed without their knowledge, hence the reason it was a conditional nomination, dependent on many other factors. Next question. Where in the Central Bank's charter is there any reference to a conditional nomination? Through you, Madam Chair, the charter does not speak of a conditional nomination. As I explained in my presentation, the Council of Ministers gave its blessing to a candidate I nominated, provided that certain conditions were met. As ministers, we are permitted to bring matters forward within the Council, and the bank charter does not determine what I may or may not bring to the Council of Ministers for agreement. As previously stated, and out of respect for the Council of Ministers and the sensitivity of the matter, I chose to follow that approach. Next question. Who is the first in line of legal advice for government decisions? Which department or office? Through you, Madam Chair, the first legal advice would come from the minister's cabinet, as most ministers have a legal advisor within their cabinet. In addition, legal advice may be obtained from the Department of Legal Affairs and the government's legal counsel. Furthermore, ministers have a budget for consultants, through which legal advice can also be sought from external entities when necessary. Legislative matters, however, are processed through legal affairs and subsequently the Council of Advice. Next question. When the minister said she pleaded with the former Minister of Finance to keep the chairmanship for St. Maarten, was that verbal or by email? And can the minister share that email? Through you, Madam Chair, the conversation between myself and the former Minister of Finance of Curacao took place face-to-face during his courtesy visit to St. Maarten in June 2024, during which various topics were discussed. It did not take place via email. In addition, there is a long-standing gentleman's agreement whereby the chair position rotates between St. Maarten and Curacao. Next question. Was the former nominee presented to the SBOD before his name was discussed for a potential conditional nomination and presented to COM? Through you, Madam Chair, no, he was not. As I explained, Madam Chair, the process had only just begun, and my action was taken as a result of the SBOD not recommending a candidate and my intention to ensure St. Maarten gets the chair. Next question. Did individuals or candidates submit applications for the post? Through you, Madam Chair, no, there were no applications. The position of chair of the Supervisory Board has never been publicly advertised. This is consistent with the manner in which a chair of the CBCS is selected, which does not involve a public advertisement, but is based on candidates known or familiar to the board members. However, this matter was discussed with the board, and in the interest of transparency, it has been suggested that the updated bank charter provide for the public advertisement of this key vacancy in the future. This would ensure that qualified individuals who may not be known to the board members or their networks are also given the opportunity to be considered for the position. Next question. Where did these candidates come from? Through you, Madam Chair, if the Honorable MP is asking about where they live, all the persons I considered as potential candidates live on St. Maarten. Did the minister, next question, conduct the search alone or with others? And if so, with whom? Did the minister research on her own, or was it a collaborative effort? How exactly did this search take place? Through formal procedures or informal consultation among friends? Madam Chair, through you, we are a small community, and in this context, qualified candidates with the necessary potential are generally known. As previously stated, some individuals who were not interested may have had conflicts of interest or was unwilling to serve. This is also the manner in which the board selects the chair. Ultimately, I chose a candidate who is a lawyer and who has previously served on the Supervisory Board of the Central Bank and therefore possesses the relevant knowledge and experience. However, as previously stated, this matter has been discussed with the SBOD, and for the future, it has been suggested that vacancies be publicly advertised. This will be proposed for inclusion in the updated bank charter to further enhance transparency and ensure that qualified individuals who may not be known to the board or its networks are also given the opportunity to be considered. Next question. Does the minister agree that in the spirit of the Central Bank Charter, there could be no political interference and that the government should maintain a hands-off approach in such appointments, in other words, good governance? Madam Chair, through you, this is an issue that was addressed in detail during my presentation. The question is, what exactly is meant by political interference? The Charter of the Bank is very clear on this point, specifically in Article 18. Article 18 states that neither the bank nor members of the management board nor members of the supervisory board may seek or accept instructions from government or political bodies. Likewise, government are required to refrain from any attempt to influence how the bank's boards carry out their duties. Madam Chair, I have fully respected and adhered to this principle. At no time have I interfered in the day-to-day operations of the Supervisory Board or the Management Board, nor have I given instructions to any members to act in a particular way. Next question. Can members of Parliament receive all relevant documents, including the advice on the nomination? Madam Chair, I am willing to provide Parliament with relevant documents that help clarify today's debate, and I will submit my presentations for ease of reference. However, under Article 62 of the Constitution and Articles 11 and 12 of the National Ordinance on Open Government, information may be provided only where disclosure does not conflict with protected interest. Information cannot be shared where it would harm the interests of the country or the kingdom, violate personal privacy, contain identifiable policy views, or where the interest in disclosure does not outweigh concerns such as economic or financial interests, privacy, disproportionate disadvantage to parties involved, or relations within the kingdom or with other states. In this case, the nomination and appointment process is still in preparation and must take place jointly with Curacao. Disclosure at this stage would negatively affect that cooperation. The documents also contain personal data of individuals who do not hold public office, and disclosure would violate their privacy. Having weighed these interests against the request for disclosure and noting that no nomination or appointment has been made, I am unable to share the requested documents with Parliament at this time. Next question. The former candidate said that he read his own advice and that all political leaders know about this. Now, is the former candidate lying? Through you, Madam Chair, I wish to be very cautious as the Honourable Member of Parliament is referring to statements allegedly made by someone who is not present to confirm whether such statements were in fact made. As such, I cannot confirm the accuracy of those statements. What I can state is that the advice was not shared by the Cabinet of Finance with any external parties. The decision of the Council of Ministers was leaked, and incorrect information was subsequently made public. If any other documents were shared, I am not aware of this. However, neither I nor anyone within my cabinet shared the advice externally.
Minister, I need to ask you to pause there one moment, and not the last answer that you gave, but the one before that on request of MP York. If you can repeat that answer. So not the last one, but the one before, please.
So the question referring to, or the answer referring to the question, the former candidate said that he read his own advice?
Before that.
Okay.
Okay, you understood? Okay, if you could repeat that one, please.
Sure.
I'm just being extra nice today, so you may repeat it.
No problem. I stated that I would be willing to provide Parliament with relevant documents that help clarify today's debate, and I will submit my presentation for ease of reference. However, under Article 62 of the Constitution and Articles 11 and 12 of the National Ordinance on Open Government, information may be provided only where disclosure does not conflict with protected interests. Information cannot be shared where it would harm the interests of the country or the kingdom, violate personal privacy, contain identifiable policy views, or where the interest in a disclosure does not outweigh concerns such as economic or financial interests, privacy, disproportionate disadvantage to parties involved, or relations within the kingdom or with other states. In this case, the nomination and appointment process is still in preparation and must take place jointly with Curacao. Disclosure at this stage would negatively affect that cooperation. The documents also contain personal data of individuals who do not hold public office, and disclosure would violate their privacy. Having weighed these interests against the request for disclosure and noting that no nomination or appointment has been made, I am unable to share the requested documents with Parliament at this time. The next question, how can Parliament be denied access to the advice while the nominee himself reviewed or helped draft it?
Minister, with your indulgence, I see MP Doran is seeking to make an interruption, which I will allow at this time. MP Doran?
Thank you, Madam Chair. Madam Chair, through you to the Minister, I heard the Minister mention that she cannot confirm and or deny. Right, it's true, literally.
MP?
Thank you, Madam Chair. Through you, Madam Chair, I heard the Minister mention that she cannot confirm and or deny that the prospect candidate at the time read the advice. I can confirm 100% certainty, as well as everyone that was in the court that day, that those were the words verbatim. I read the advice. Through you, Madam Chair, the Minister just mentioned that the advice was leaked from COM. So my question through you to the Minister, what has been done since then? Was an investigation conducted, concluded as to which minister or which staff member leaked this COM information? Because COM is a very delicate and confidential setting. So I would like to know through you, how did the candidate receive his advice to read it from the COM? And what was done to resolve this matter?
Thank you, MP Doran, for that interruption. And the minister would have to indicate whether it's something she can answer to now or what, how she would reply to the specific question, kind of for clarification that the MP posed based on a statement by the minister. Thank you, MP Doran. Minister, you may continue taking MP Doran interruption into consideration as well.
Madam
You
Chair?
may sit, MP Doran.
Thank you, MP Doran, for your clarification question. To be quite honest, again, I was not in the courtroom. I didn't even, there were persons who made some statements like you just made to me concerning what was said. But again, like I stated, no document, no advice was shared from my cabinet. I did indicate that the advice was leaked by COM. You asked if there was any investigation done. At this time, no investigation was carried out.
I see MP York is requesting for an interruption. You may, MP York, and I remind you of the rules surrounding interruption, short, to the point, assertion, clarification. It can be inserted as an extra round in the discussion. So with that, you may use the interruption lectern.
Thank
MP
you.
York.
Thank you, Madam Chair. Madam Chair, I find it very interesting to hear today that a document was leaked from the COM, by the COM. We never alluded to such a document or such a leak. As a matter of fact, I'll take it even a step further, because I was also in the courtroom that day, and it can also be found in the notes, most likely from the proceedings. The person in question, or the person that we're referring to, speaking about right now, used the term, I received the documents from the cabinet in court. So to hear the minister now first refer to leaked documents from COM and now explicitly saying nothing came from her cabinet when the nominee at the time explicitly said, I received it from the minister's cabinet, I find it to be quite confusing, quite perplexing, Madam Chair, and I hope that the minister could bring some type of clarification to this matter.
Thank you, MP York, for that interruption. Minister, you may continue taking into consideration the interruption by MP York.
Thank you, Madam Chair, and thank you, MP York. Again, I will repeat, I was not in court. I can't speak for what the individual stated in court. I know for a fact that no document was leaked from my cabinet, and I can state this, the reason why I repeatedly said that the advice or the discussion that was held in COM was leaked was because before COM even ended, I received a call from various persons concerning this nomination. So hence why this could have only been leaked from within COM if other persons contacted me, even before COM was ended.
Thank you, Minister. I will allow MP Irion's interruption since he is at the lectern, and then I will ask you, unless it's really pressing, that we could allow the Minister to get a little further in her answering, and then, of course, I'll continue to allow interruptions. So, MP Irion, you have the floor.
Thank you, Madam Chair. I'd like to also state that the reason for interruptions is actually to interrupt. So I understand the minister wants to continue, but there's a reason why we invented this position. And I think it's up to the MPs to decide why it's important to interrupt. Minister,
MP
through you, Madam
Irion,
Chair,
just
I'd
so
like
that
to-
we have the record straight, interruptions are up to the discretion
I
of the
understand
chair.
that. I
So if
understand
you
that.
just respect that, please, you may have your interruption.
Thank you, Madam Chair. The minister mentioned that the document was leaked and it came from COM, and I think NPR alluded to the fact that what was said in court about coming from cabinet, and I'd like the minister to confirm or deny if the minister is aware that her cabinet also sent documents or information, because the nominee sent your cabinet a email request, and these are court documents, it's officially submitted, sent your cabinet information, questions, asking for documents of the past, right, to support in the court proceedings. So I would like to know if you approve that discussion, that dialogue, which is documented, is in court, right, and your staff, I assume also have it. Because we can't say things are leaked and you don't know, because I also know there's official communication from your cabinet to the nominee the night before the court. Thank you.
Thank you, MP Irion. Your interruption is clear, and Minister, you may continue and take into consideration the interruption by MP Irion. Minister, you may continue.
Thank you, Madam Chair, and thank you, MP Irion, for that interruption. And again, I stand by my statement. I am not aware, and I am not aware of anything being leaked by my cabinet. And for certain, I want to state that I know that my cabinet members would not leak a document without my permission.
Minister, you may continue with your answers to the members of Parliament.
I believe I was on the question for MP York, who asked, how can Parliament be denied access to the advice while the nominee himself reviewed or helped draft it? Madam Chair, I would like to refer to my previous answer, where reference is made to someone who is not present, and my explanation that I am unable to share the requested documents based on our Constitution in conjunction with the National Ordinance on Open Government. Next question. The MP's concerns are the inconsistencies on how we got to the former conditional nominee. Can the minister explain the entire process from the search to the conditional nominee, and not just what was done, but whether it was done correctly? Through you, Madam Chair, I noticed that the Honourable MP still has some concerns with the term conditional nomination. I won't belabor the point any further other than to say that at this time, the nomination was given the green light by the COM, provided certain specified conditions were met, which are the exact same conditions under which the COM gave its approval to a nominee back in 2021. Madam Chair, with your permission, I will now turn to the questions posed by the Honourable MP Irion. When the minister says there is a difference in legal opinion, whose opinion is she referring to? Madam Chair, this matter was discussed with various legal professionals, and I can state that no two interpretations were exactly the same. There are several members of Parliament who are distinguished lawyers, and they have expressed their views on this matter both on the floor of this Parliament and outside of it. Those legal opinions are their own, and each lawyer may interpret the matter differently. Even within the same legal framework, provisions can be viewed in multiple ways, which underscores that the law is not always straightforward. This is precisely why we have courts and judges to ultimately interpret and adjudicate such matters. Next question. Was her legal advice based on her cabinet's counsel, the Department of Legal Affairs, or external firms such as Brooks and Associates? Is that the legal advice that the minister is referring to in her answers? Madam Chair, through you, I want to say that with all due respect to the Honourable MP, whose experience and expertise on these matters are not in doubt, that the CBCS Charter does not demand that the respective ministers of finance of St. Maarten and Curacao base their nominations on any legal advice. It does not require the SBOD to do so. either regarding their recommendations. I chose to seek advice or additional advice because of the uncharted waters in which we found ourselves with the SBOD's failure to submit a recommendation. Had I received the recommendation, we would not, or we would most likely not be here today. Today, we would have had a St. Maarten chair at the CBCS. Number 3, why did the government not seek internal legal affairs advice on this matter, as is standard for all legislation and decisions? Through you, Madam Chair, I do not believe that the nomination of a candidate for the chair of the SBOD is a legislative matter. 4, is this the new practice of the coalition to bypass internal legal review and rely on external lawyers? Is this how the coalition operates? Through you, Madam Chair, I do not speak for the coalition. However, may I point out that government, including previous ones, retains and contracts external law firms, which it consults on various matters. It is not unusual to do so, and as previously stated, this is not a legislative matter, which requires review by legal affairs.
Sorry, Minister, members, your little murmuring is audible, so I just ask you to take that into consideration, please, while the meeting is ongoing. Minister, you may continue.
Why does the government not have a position from its own internal lawyer? Madam Chair, I am unclear as to what alternative position the honourable member expects the government to take beyond approving the candidate nominated by me under clearly defined conditions. Furthermore, Madam Chair, the honourable member is well aware that my cabinet is supported by a highly competent legal advisor who was in fact retained from his own cabinet. It should also be noted that the position of an internal legal advisor is not subject to public disclosure, and that as minister, I am entitled to base my decisions on one or multiple legal advices as I deem appropriate. Did the minister actually establish a formal selection committee to choose the central bank nominee, or was the so-called committee simply an informal group of acquaintances assembled without proper procedure? Madam Chair, for the sake of clarity and to avoid any misunderstanding, allow me to correct the record. When I use the term committee, as stated previously, I did not intend to suggest a formally constituted body or a procedurally established committee. I was referring to a consultative discussion with trusted advisors whose role was to provide input and perspective. Ultimately, the responsibility for the nomination rests solely with me as minister. I considered the advice provided, exercised my own judgment, and made the decision accordingly. With that clarification on record, I consider this matter sufficiently addressed. Next question. Who were the members of this Friends Committee, and why can't any be named? Madam Chair, through you, there was no Friends Committee. Number 9, the MP referenced a statement. Nothing was done by the predecessor, but today, can I assume her legal advisor was part of all emails? I can send letters to Parliament with her legal advisor in the CC. Madam Chair, I stand by my statement that between 2021 and 2024, the process to appoint neither members to the board nor a chairperson of the SBOD was not finalized, for whatever the reason. Otherwise, we wouldn't be dealing with this issue today. However, Madam Chair, I must admit that the Honourable MP did something when he was the Minister of Finance. Along with his counterparts in Curacao at the time, he rejected the recommendation of a candidate from Curacao represented by the SBOD for the same position of chairperson of the board. That was before the subsequent nominee was later accepted, although the process was never completed. On the issue of my legal advisor, Madam Chair, the Honourable MP can testify to the professionalism and competence of the individual who had also worked for him. So, Madam Chair, the Honourable MP is free to share whatever documents he feels Parliament needs to have. We do not know if the legal advisor was a part of all emails, but from all I know, when someone is copied in on a document, it is the equivalent of an FYI. It does not require any formal action from that person. But of course, I stand corrected. And at the end of the day, during the tenure of the former Minister of Finance, various actions may be stated to have been taken. However, the fact remains that no members of the CBCS Supervisory Board were appointed, nor was a chair of the CBCS appointed during that period. Number 10, did the minister's cabinet inform her that the individual nominee was already considered or acting as chair before her conditional appointment? Madam Chair, first of all, there was no conditional appointment of anyone by me. What we have been talking about is a conditional nomination. Let us not act as though those two words are synonymous. Furthermore, Madam Chair, I doubt if it is customary for any minister to be sharing what they were told or not told by their cabinet. The person proposed for conditional nomination is not on the board of the CBCS. Next question. Was the minister misinformed by her advisors about the nominee's status, or did she misunderstand? Through you, Madam Chair, as Minister of Finance, I take full responsibility for the decision I make. Ministers receive advice from various sources. However, to suggest or imply that I was misinformed by my advisor is, in my view, inappropriate. I was adequately informed, did not misunderstand the matter, and I will not seek to shift responsibility onto anyone else. Can the minister provide the exact timeline of when the committee was formed, when it gave it advice, and how the advice was delivered? Meeting, email, WhatsApp. Through you, Madam Chair, as previously stated, the use of the term committee has been corrected for the record. There was no formally constituted committee and therefore no formal timeline, mandate, or documented advisory process to report. The consultations were informal and advisory in nature, and the ultimate decision was taken by me in my capacity as minister. Can the minister share her letters sent to the central bank dated October 16th and 21st to clarify discrepancies? Through you, Madam Chair, on November 4, 2025, various letters from the CBCS were sent to all members of Parliament, including the letter dated 21st of October, 2025. I am not aware of any letter dated 16th of October addressed to the CBCS as referenced by the Honourable Member. The correspondence that was sent to the CBCS was shared with all members of Parliament. However, my email of October 16th, 2025, we informed Parliament that we are awaiting feedback from the central bank. Perhaps the MP is referring to that email message. Why was there a one-week gap between requesting feedback October 16th and sending the formal letter October 21st? Through you, Madam Chair, just for clarity, we did not request feedback on October 16th. To be clear, we requested feedback from CBCS on Tuesday, October 14th, 2025 at 12 p.m. In addition, we received a letter from the Supervisory Board on October 14th, 2025 and responded on October 21st, 2025. I'm not sure what the expectation is with that question exactly, but I hope to have clarified the facts from my side at least. Why did government instruct no appointments during elections, but then proceed afterwards? Madam Chair, I am not aware that government instructed anyone in the manner suggested, as I was not a part of government at that time. If the Honourable Member is instead referring to the general principle that a caretaker government is reminded to refrain from taking new decisions that could bind an incoming government, that is a customary and widely accepted practice. This, however, does not prevent a caretaker government from continuing the day-to-day administration or handling ongoing matters. The fact remains that during my predecessor's tenure, no chair and no board members were appointed to the CBCS. Can the minister share all letters and correspondence with the CBCS board? Through you, Madam Chair, CBCS letters received and sent were shared with the members of Parliament. Why did the minister respond to an article of the Antillean Dagblad but not on other media? Through you, Madam Chair, I think everyone has the right to choose which articles they respond to, when and in what media. I am sure that the Honourable MP has exercised this right on several occasions. Why did the minister request Mr. Bloom to go to the radio? Through you, Madam Chair, I suggested that Mr. Bloom go on the radio because he has a legal background and extensive knowledge, having previously served on the board. As such, he was well positioned to explain the process and provide the necessary context, which he did. Is it true that Mr. Bloom had 7 months to decide whether to accept, and were all political leaders informed of his nomination? Through you, Madam Chair, as previously stated, from January through August, I was awaiting a name from the Central Bank's board. During that period, I did make informal inquiries with certain individuals regarding their willingness to serve, and he was one of them. When I approached him again in August, he indicated his willingness to accept. It is therefore incorrect to suggest that he had 7 months to decide. Had I received a recommendation from the board during that time, we would not be here today. As previously stated, the decision of the Council of Ministers was leaked, resulting in the public becoming aware of the conditional nomination. Did Mr. Bloom see or help draft the advice on his own nomination? Did he get to see an advice period? Through you, Madam Chair, as previously stated, the CBCS advice drafted within my cabinet was not shared with anyone outside of the cabinet. Madam Chair, I will now move on to the questions of MP Doran asked through his colleague MP Irion. MP Doran, through MP Irion, asked, regarding the central bank, in what form was the minister's pleading with the former Minister of Finance? Was a letter sent? Can we see that correspondence? Through you, Madam Chair, as previously stated, the conversation between myself and the former Minister of Finance of Curacao took place face-to-face during his courtesy visit to St. Maarten in June 2024, during which various topics were discussed. It did not take place via email. In addition, there is a long-standing gentleman's agreement whereby the chair position rotates between St. Maarten and Curacao. Will the minister finalize the central bank process now, given the delay? Madam Chair, as I explained in my presentation to Parliament, the entire process will have to start over. Allow me to emphasize once again that in accordance with the CBCS Charter, the nomination process is a joint decision of the Ministers of Finance of St. Maarten and Curacao. I can assure the honourable member through you, Madam Chair, that I will take up this matter with my new counterpart in Curacao as soon as possible. Madam Chair, the Honourable MP Kotai asks some very important questions, which I will answer as follows. However, I would ask you, Madam Chair, if I can have 2 minutes recess.
Minister, thank you so far. In fact, I'll adjourn this meeting now for 5 minutes, which I'll be doing as we continue on with the meeting every so often. So this meeting is hereby adjourned for 5 minutes. Members of Parliament, ladies and gentlemen, Minister of Finance and your support staff, welcome back. We immediately continue. We had a brief adjournment during the answering by the Minister of Finance, and now the Minister will continue with her answers to members of Parliament. Minister, you have the floor.
Thank you, Madam Chair. I will proceed with questions by Bikotai. How often is the Supervisory Board of Directors of the Central Bank required by law to meet? Through you, Madam Chair, Article 27.1 of the Charter states, and I quote, "The Board of the Supervisory Directors shall meet at least every 2 months, and furthermore, as often as is deemed necessary or desirable by the chairman or 2 members of the board or the president of the bank." So the SBOD is required by law to meet at least every 2 months. Where is this meeting held and who can attend such meetings? Madam Chair, the meetings of the SBOD can be held on Curacao or St. Maarten. In addition to the members of the Supervisory Board of Directors, the members of the Management Board of Directors attend this meeting, and as per Article 27.4 of the Charter, the President of the Bank shall report on the general economic and financial development of the countries and on the bank's policy and management. At least once a year, the Supervisory Board of Directors meet without the presence of the Executive Board and shall discuss 1, its own performance and the performance of the individual members of the Supervisory Board, taking into account the criteria established by the Board as included in the appendix to those regulations. 2, the performance of the Executive Board as a body and the performance of its individual members. And 3, the performance of the individual committees of the Supervisory Board, as well as the conclusions and recommendations formulated by these committees. Next question, how often must the Ministers of Finance of Curacao and St. Maarten meet jointly? Madam Chair, Article 24.1 of the Charter states that the ministers shall hold consultations at least once every 6 months on affairs regarding the bank. In addition, the ministers act as representatives of the entitled asset holders and therefore meet in that capacity at least once annually, Article 32.1. This annual meeting of the entitled asset holders shall be held within 6 months after the end of the financial year, Article 32.2. Madam Chair, through you, I can inform the Honourable MP that in the last year, I have met with the former Minister of Finance of Curacao once. I have met with the current Acting Minister of Finance of Curacao once, since he became responsible for that portfolio during a shareholders meeting held in December 2025. Next question, how often are the Ministers of Finance required to meet with the Supervisory Board of Directors? Madam Chair, the same Article 24.1 states that the Ministers may invite the Board of Management and or Board of Supervisory Directors to attend said consultations. In other words, the law does not specify the number of times the Ministers of Finance should meet with the SBOD. Has this been happening? If so, how often? Through you, Madam Chair, I have met on several occasions with the St. Maarten members of the Supervisory Board of Directors. In addition, at my request, I met with the full board to address matters relating to the former financial director of the CBCS in July 2025. Furthermore, in December 2025, during a shareholders meeting, together with my counterpart, we met again with the entire CBCS board. In addition to these meetings, I also maintained communication with the board through written correspondence throughout the year. How often must they meet with the management board, and how many times did that occur in the past year? Madam Chair, Article 24.2 of the Charter stipulates that the President of the Management Board shall periodically, but at least once every 3 months, hold consultations with the ministers on the financial and economic policy. Regarding the second part of the Honourable MP's question, I am afraid, Madam Chair, that due to scheduling challenges, the required quarterly meetings with the Management Board have not taken place in person. However, the President of the Management Board has remained in constant communication with my person. Now, Madam Chair, allow me to answer the questions by the Honourable MP Roseberg. MP Roseberg asked, how does the 2016 Joint Court decision on temporary appointments relate to the current situation? Madam Chair, Article 25.9 of the Charter was triggered due to a stalemate in the appointment of the Chair of the Supervisory Board of Directors. By letter dated June 13, 2016, the President of the Joint Court of Justice clarified to the Ministers of Finance of Curacao and St. Maarten that a temporary appointment made under Article 25.9 ends only once both countries have made a definitive appointment to fill the vacancy. Such temporary appointments are not subject to a fixed term and are therefore not limited to the 4-year term applicable to appointments made by the countries. As a result, temporary appointments, such as those made on March 26, 2012, did not expire after 4 years. As a result, vacancies had not yet been filled. This clarification confirms that current temporary members who have served beyond 4 years remain validly appointed until definitive appointments are made. Next question. President of the Court state that a temporary appointment term does not count. Has the tenure of St. Maarten's temporary members exceeded the statutory term, and how is that being treated legally? Madam Chair, as I have previously stated to Parliament, there is a very fundamental difference of opinion with the SBOD on the interpretation of temporary. The statutory term of office of members of the SBOD is 4 years, can be extended consecutively by another 4 years. In my opinion, Madam Chair, practically all the temporary members of the SBD has exceeded the statutory term of 4 years. However, in response to my inquiry, the SBD contends that for them, temporary means until they have been formally appointed. In other words, their first or second term of 4 years will begin when they receive their national decrees. I only received this position just about 2 months ago. Next question. What was the reason why the 5 temporary members were not formally appointed? I understand that the chairman is important, but why does the chairmanship seem prioritized over filling the 5-member seats? Through you, Madam Chair, the reason I prioritized the appointment of the chair, as I have previously explained, is that the board members must be appointed jointly by both countries. At the time, the former Minister of Finance of Curacao was still in discussions regarding his members and was requesting new names from the CBCS board. It was therefore agreed to wait or await his process so that the appointments could proceed together. As such, I focus on the chair appointment while my counterpart addressed the matter of the board members of Curacao. Do you believe that a minister is allowed to nominate without a nomination of the board? Madam Chair, if I understand the question of the Honourable MP correctly, she is asking if I have the authority to nominate a candidate without the board recommending that candidate. As I have previously stated, I requested that recommendation, but up till today, for whatever reason, I have not received one. I believe I acted judiciously to address what has become a dysfunctional and untenable situation that the Charter itself does not foresee and therefore provides no remedy for. However, as the board is currently in the process of updating the Charter, I have suggested that these matters be addressed therein. I will also be submitting a list of proposed items for inclusion with the aim of preventing a similar situation from arising in the future. Did the ministry in any shape or form consult or communicate with the board members formally or informally before acting? Through you, Madam Chair, yes, I did. What happened to the 3rd St. Maarten member who was recommended more than a year ago? Through you, Madam Chair, I have previously explained why my focus was on the appointment of the chair. As it pertains to the individual in question, I am informed that the individual has since been various other boards. We are currently undertaking the necessary due diligence and have received confirmation that this individual would be required to undergo screening again. Do you agree that good governance requires formal appointments of all temporary members, and why hasn't this happened? Madam Chair, I do agree with the honourable member that good corporate governance is the responsibility of the Supervisory Board of Directors. Why a recommendation for the position of chairperson was not submitted is a matter I cannot answer on behalf of the board. In addition, as I have previously explained, the other board members were not prioritized at that time, as Curacao was still requesting new names from the board. Madam Chair, I do wish to be very clear on this point. The ambiguities in the Charter regarding the procedure for the appointment of board members have contributed in no small measure to the instability in the governance procedure of the CBCS that we are experiencing today. The bank charter must be updated. Does a gentleman's agreement exist alternating the chairmanship between Curacao and St. Maarten? And is it currently St. Maarten's turn? Are we safe or are we lost? Through you, Madam Chair, yes, indeed, there is a gentleman's agreement whereby the chairmanship of the SBOD alternates between St. Maarten and Curacao. It was indeed St. Maarten's turn to fill the position, which was what I was trying to do in the very first instance, and I would like to believe that we still have the opportunity. Can the minister provide documentation proving that the gentleman's agreement exists? Madam Chair, I believe by definition a gentleman is an informal, verbal, non-legally binding arrangement that is based on integrity, honor, and trust, and good faith between two or more parties. MP Roseberg saw several, Madam Chair, through you, several documentations about the communication and saw that there were several reactions. Did the board respond to the minister's letters or requests for meetings? Did that happen? When is the next meeting scheduled? As there seems to be an impasse, I am looking at the bigger picture and asking the minister how this impasse will be resolved. Madam Chair, we are where we are today because a fundamental step in the appointment process chairperson of the Supervisory Board of Directors did not take place, namely the submission of a recommendation from the board to the ministers. I actively sought a recommendation, as I have demonstrated, but none was provided. My actions were precisely intended to avoid a situation we are facing, a situation that was not anticipated by the Charter and for which the Charter therefore does not provide a clear remedy. Since then, I met with the St. Maarten members of the board in November of 2025, in December 2025, together with my new counterpart, the Minister of Finance of Curacao, and I met with the full board. That meeting was constructive and positive. However, the agenda items relating to the chair and the board members were not addressed at that time, and it is expected that the meeting will be reconvened to do so. It is my intention to meet with my counterparts in Curacao at the beginning of this year to discuss possible solutions to the current situation, particularly as it relates to the appointment of board members. All meetings to date have been positive. My objective has always been to ensure that we have a complete board, with the appointment of the chair being a key element. My intention remains to maintain open and constructive communication with my counterparts and with the board, and to ensure that key matters are improved going forward. This includes updating the bank charter and clarifying the procedures for the appointment of board members and the chair. Ultimately, this requires cooperation and coordination between all parties, as we all need each other for this to work effectively. Does the minister acknowledge that an impasse exists? Through you, Madam Chair, since the meeting held with the entire board and my counterpart minister in December, I am hopeful that we can move out of this impasse. However, as previously stated, the key topics relating to the chair and the board were not discussed at that meeting, notwithstanding that the meeting itself was very constructive. Nevertheless, I deem it important that the bank charter be updated to prevent such situations in the future. Clarifying these procedures will strengthen the CBCS as an institution and enhance both transparency and integrity of the entity. Madam Chair, permit me to address questions posed by the Honorable MP Labega. MP Labega asked, since your last appearance, what steps have been taken to A, appoint members who passed their screening February 2024, and B, reopen discussions with SBOD on nominating a chairperson? Through you, Madam Chair. The reason I prioritize the appointment of the chair, as I have explained, is that the board members must be appointed jointly by both countries. At the time, the former Minister of Finance of Curacao was still in discussions regarding his board members and was requesting new names from the CBCS board. It was therefore agreed to await his process so that the appointments could proceed together. As such, I focus on the chair appointment while my counterpart addressed the matter of the board members of Curacao. My intention is to have a meeting with my new counterpart to get his perspective on the current board members of Curacao and assess if we can now proceed. Answer to Part B, through you, Madam Chair. Since then, I have met with the St. Maarten members of the board in November 2025. I have also sent letters and received confirmation from the board that a name for the position of chair would be provided. The meeting held in December included agenda items relating to the chair and the board members. However, those matters were unfortunately not addressed, and the meeting will therefore be reconvened. It has now been nearly 1 year since I received the letter from the board indicating that strong candidates had been identified, and to date, I have not received a proposed name. Nevertheless, I remain hopeful that once the meeting is reconvened, we will obtain greater clarity on that matter. Can you explain the process for selecting SBOD members and the length of their terms? Madam Chair, through you, I want to thank MP Labega for that question. Article 25 of the Charter establishes the procedures to follow for the appointment and dismissal of members of the SBOD. The procedures can be broken down into 5 steps, although we have focused solely lately on 3 of them. They are as follows. 1, SBOD recommends candidates with 5/6 majority for the chairperson. 2, ministers of finance of both St. Maarten and Curacao jointly nominate the candidates. 3, the candidates are screened by the relevant national security agencies. 4, joint appointment by national decree of successful candidates. 5, oath of confidentiality administered by governors, Article 31. All terms are for a period of 4 years, and the members are immediately eligible for reappointment once more upon their resignation. In addition, you have the temporary appointment by the President of the Joint Court of Justice, which term is until the appointment by the countries are formalized. What is temporary? They were temporary for 4 years. Does this minister plan to appoint the members that passed the screening, or is it the intention to look for new members? Madam Chair, as explained throughout the Charter, the term temporary is understood to mean a period of up to 3 months. However, in reality, they have now been temporary for 4 years. As for the second part of the question, Madam Chair, I have received 3 names for each of the 3 St. Maarten board positions. While I am prepared to proceed with 1 board member for certain, I am not yet in a position to state if I will proceed with the other 2, as there are additional matters that need to be taken into consideration. If not, the current temporary members seeing the time they have served, how is the timeline looking? Madam Chair, all current members of the SBOD hold a temporary status. Given the length of time, some members have now served exceeding 8 years in certain cases. This is not desirable by any standard and poses a governance risk in itself. This is a matter I would like to discuss further with my counterpart. Together with the board and my counterpart in Curacao, I am hopeful that we can reach a solution that is in the best interest of the CBCS as an institution. Did the minister ask Hyder Bloom to go on the radio? Was he instructed to go on the radio by the minister? Through you, Madam Chair, as previously stated, I suggested that Mr. Bloom go on the radio because he has a legal background and extensive knowledge, having previously served on the board. As such, he was well positioned to explain the process and provide the necessary context, which he did. Madam Chair, the Honorable MP Lewis asked the following questions. Why has it taken 20 months for the SBOD to propose a new candidate? Through you, Madam Chair, Honorable Member, I honestly don't know. All I know is that I requested a recommendation and have not received one to date. It will be 1 year on the 31st of January 2026 since I received the letter from the board indicating that very suitable candidates had been identified. 1 year. Based on what qualities were the members of the SBOD appointed? Madam Chair, Article 25.10 of the Charter describes the qualities the Honorable MP is asking about. The article states, and I quote, "The members of the Board of the Supervisory Directors shall be competent, incorruptible, and independent in conformity with the requirements set forth in the job profiles contained in the regulations referred to in paragraph 11. Paragraph 11 states, and I quote, upon consultation with the meeting of the entitled asset holders, the Board of the Supervisory Directors shall establish rules concerning its job profiles and the performance of its duties. These rules shall be published in the journals in which each country advertises its official notices. Part of the rules of order of the Supervisory Board of Directors include these profiles of the Supervisory Board of Directors. Does the Charter not state how long the SBOD has to submit a recommendation? Through you, Madam Chair, the Charter does not stipulate a specific time frame within which the SBOD is required to submit a recommendation. Unfortunately, this lack of clarity is precisely why we find ourselves in the situation we are in today. The bank charter does not clearly indicate what should happen if no name is provided. Surely it cannot be the intention that we wait indefinitely. These are critical matters that must be addressed in the bank charter to safeguard the integrity of the CBCS. We are speaking about an institution that oversees key financial institutions, yet it is currently operating without a complete board. This situation underscores the urgent need for clearer procedures and timelines within the charter. Has the Minister had any discussions with the Curacao government with respect to the Minister of Finance on this matter moving forward? Will we lose our chance to fill the position of chair? Madam Chair, I have indeed been in discussion with the Minister of Finance of Curacao, but unfortunately, we have not been able to deal with this particular matter in detail, although it was part of the agenda of our meeting. This was due to the fact that the current Minister of Finance of Curacao had to be pulled away to attend other urgent matters during our discussions. It is my intention, as I've stated earlier, to continue those discussions with a view to finding feasible solutions that will restore stability to the CBCS governance structure. Madam Chair, the Honourable MP Peterson posed the following questions, which, with your permission, I will proceed to answer. The Honourable MP expected a trajectory of accountability, but none. So he repeated his opinion. Everyone speaks in article, but let me speak to the people. The law states what the government can do, and therefore it does not state what the government can recommend in absence of a recommendation from the SBOD. We speak about Article 25, Lit. 3. I will come back to this.
Minister, just a heads up. I don't know how far along you are with the questions of the MP who you are currently answering, but if it's just a few minutes from now, I then, after those answers, will break for lunch for 30 minutes. However, if it's still many more from the MP who you are presently answering, then I will break now. So if you can just indicate to me, Minister, how many more answers you have to the MP with whose questions you are dealing right now.
Thank you, Madam Chair. I just started with the first, and that MP has 12 questions.
Okay, let's finish this MP, and then we break for half an hour. Minister, you may continue.
Thank you, Madam Chair. Through you, I have provided Parliament with the reasoning and motivation on this matter. To be clear, the government did not appoint a chairperson of the Supervisory Board of the Central Bank, nor was any joint nomination made. As such, there is no violation of Article 25, Paragraph 3 of the Bank Charter. The only action taken was a Council of Ministers' approval to proceed with a conditional nomination, subject to full compliance with the Bank Charter, with the sole purpose of breaking the existing standstill and initiating discussions with the Minister of Finance of Curacao. The CBCS Charter assigns no role to the Council of Ministers in formal appointments of Supervisory Board members and provides no explicit remedy where no recommendation is forthcoming. However, basic principles of good corporate governance dictate that an institution as critical as the central bank cannot remain without a properly constituted board, including a chairperson. Given that the charter is outdated and currently under revision, the situation is not clearly regulated. Allowing such a deadlock to persist is not in the interest of the bank or of St. Maarten, and it is for that reason that I acted to break the impasse. Did the minister meet with the SBOD about the topic, the legal issue? Why not? Madam Chair, yes, I have been in regular communication with the SBOD. I also sent them letters requesting to submit their recommendations. The situation we are facing right now, Madam Chair, goes beyond a legal issue and strikes at the very core of the governance structure of the CBCS. It is a chronic situation that dates back to almost to the very inception of the CBCS in 2010. A meeting with the SBOD alone will not solve this. In my view, it definitely requires a legislative review of the charter itself and a discussion with the Minister of Finance of Curacao. Is there an unslackable slide for Mr. Yardim? Madam Chair, there is a draft dismissal decree concerning Mr. Yardim, which, in accordance with Article 20 of the Charter, must be decided jointly with the Minister of Finance of Curacao. For clarity, Mr. Yardim served as a member of the Management Board of Directors of the bank, not the Supervisory Board of Directors. Letter dated October 12th, he did not receive a proposal. Did the SBOD contact you? Why was this not yet done? Can we see those correspondences? Madam Chair, through you, I am not aware of a letter of October 12th. Maybe the Honourable MP is referring to my letter dated December 12, 2024 to the SBOD. Madam Chair, I sent a friendly reminder on January 21st, 2025, to which I received a response from the SBOD on January 31st, 2025. I shared the relevant correspondence of the SBOD with the Parliament on November 4th, 2025. Or perhaps the MP is referring to a letter of October 21st, 2025, on which the Supervisory Board of Directors reacted by its letter of November 5th, 2025, proposing to discuss this matter further in person with both representatives of the asset holders of the CBCS, which discussion still has to take place. The MP, Madam Chair, heard the board failed, but the minister cannot provide a timeline. Did SBOD actually contact the minister to meet after the letter of the minister? Madam Chair, no, the SBOD did not request a meeting after my letter, and as I have stated earlier, I provided Parliament with an overview of the correspondences leading to the public meeting of Parliament of October 17, 2025. Why were the temporary members up to now not appointed? It seems that the SBOD does not work along, but that is kort door de bocht. Through you, Madam Chair, the reason I prioritize the appointment of the chair, as I have explained, is that the board members must be appointed jointly by both countries. At the time, the former Minister of Finance of Curacao was still in discussions regarding his board members and was requesting new names from the CBCS board. It was therefore agreed to await his process so that the appointments could proceed together. As such, I focus on the chair appointment, while my counterpart addressed the matter of the board members of Curacao. My intention is to have a meeting with my new counterpart to get his perspective on the current board members of Curacao and assess if we can now proceed. But nothing justifies the action of COM as it is not in line with the Charter. It is simply not allowed. Madam Chair, I respect the Honourable Member of Parliament's legal opinion. However, I disagree with his position on this issue. I explained in my presentation, the Council of Ministers gave its blessing to the candidate I nominated, provided that certain conditions were met. As ministers, we are permitted to bring matters forward to discussion or for discussion within the Council. And the bank charter does not determine what I may or may not bring to the Council of Ministers for agreement. As previously stated, and out of respect for the Council of Ministers and the sensitivity of the matter, I deliberately chose to follow this approach. I would once again like to emphasize that the decision of the Council of Ministers was leaked and that the subsequent publication contained incorrect information, stating that the Council of Ministers had appointed a new chair. This is not possible, and that would not be in line with the Charter, but that was not the case, as the Council of Ministers did not appoint anyone. Can the Minister provide a list of names of the group of confidants that were involved in the selection of the nominee for the SBOD and the list of names of the supposed 9 nominees for transparency's sake? Through you, Madam Chair, I cannot provide a list of names as requested by the Honourable MP, who correctly refers to them as confidants. They are confidants for a reason, and as previously stated, several of the proposed individuals indicated they were not willing to serve. Is the COM going to retract the conditional nomination and admit that it was not their prerogative to begin with, regardless of if it was withdrawn or not. Through you, Madam Chair, with all due respect, I see no reason for the COM to retract its approval for a nomination that has been declared null and void. My understanding, Madam Chair, is that when something is declared null and void, it means that it has no legal force nor effect from the very beginning. Simply put, Madam Chair, that nomination no longer exists, so there is nothing to retract. Is the COM going to admit that they followed faulty legal advice and this is not the correct precedent set by law? Madam Chair, as I indicated earlier, this matter is not a simple or clear-cut legal issue as evidenced by the different legal views that exist. I am not in a position to speak on behalf of the Council of Ministers. However, following the nominee's withdrawal on October 16, 2025, the COM decided to formally accept the nominee's withdrawal as candidate for chairperson of the SBOD. Is the COM going to allow the charter to be executed in the correct legal way without any intervention that is not allowed by law? Madam Chair, through you, the CBCS charter does not assign COM any role in the appointment process of members of the SBD, including its chair. The role is related to the Ministers of Finance of Curacao and St. Maarten. In addition, please be aware that COM decision is conditionally with the condition that it is all in accordance with the charter. Can we get Yazet and Way advice on this matter? Madam Chair, I would like to inform Parliament that with regard to advice on appointments to Supervisory Board of Directors of the CBCS, we do not seek advice from Yazet and Way. Accordingly, there is no advice from Yazet and Way on this matter. Given that this issue is no longer under consideration, as the candidate has withdrawn his candidacy and taken into account the existing workload of the Yazet and Way department, I do not consider it necessary to engage its limited capacity further on this issue. The revision of the charter, however, will of course be submitted to Yazet and Way for legislative assessment. Madam Chair, to conclude this line of questioning, allow me to make a few brief observations. While questions have focused on the advice that informed my actions, my primary concern is ensuring that the central bank can function effectively, credibly, and in line with the sound governance principles. Madam Chair, my focus is therefore not on revisiting the past, but on addressing the situation as it exists today. Where gaps or ambiguities have been or become apparent, they should be addressed thoughtfully and, if necessary, through legislative improvement so that we can strengthen the CBCS and safeguard its future stability.
Minister, thank you for your answers thus far. As I mentioned before you continued, that at this point in time, I will adjourn this meeting for approximately half an hour, but I will put it until 1:45, giving us 35 minutes for a lunch break or any other activity that yourself or members of Parliament would undertake during this time. So, Minister, thank you. And this meeting, members of Parliament, is hereby adjourned until 1:45, 1:45. Meeting adjourned. Members of Parliament, ladies and gentlemen, good afternoon and welcome back to this public meeting of Parliament, a meeting regarding matters surrounding the Central Bank of Curacao and St. Martin in general. The Minister of Finance, after the first round of questions, is here today, has been with us to respond to questions by members of Parliament. This was started, and I now, following that brief lunch break, I now invite the Minister to continue where she left off with the answers to the questions by members of Parliament. Minister of Finance, Minister Gums, you have the floor.
Thank you, Madam Chair. As I completed the questions on Section 1 concerning the Central Bank, I now move over to questions posed by the Honourable Members of Parliament with regards to ENNIA, starting with the Honourable Member of Parliament, MP Lacroes, who asked, can the Minister provide an updated and detailed list of all recovery claims filed against liable parties, including timelines, responsible authorities, and expected returns for policyholders, and what are the main obstacles to effective recovery? Madam Chair, the Central Bank of Curacao and St. Martin has initiated several legal proceedings in the United States against the late Mr. Ansari and related parties with the primary objective of recovering and securing assets belonging to ENNIA and countering claims by the Ansari family. These include the ongoing enforcement actions in Texas seeking recognition of the Curacao liability judgment so that U.S.-based assets can be pursued, the successful defense against the Ansari's family's expropriation claim in Washington, D.C., which was dismissed on the basis of sovereign immunity, and the Chapter 15 recognition in New York that allowed the central bank to secure ENNIA assets in the United States to ensure continuity of pension payments. Madam Chair, while the late Mr. Ansari and his co-defendants appealed the original Curacao judgment, finding them liable for damages exceeding 1 billion guilders, the Joint Court of Justice has already issued an important provisional ruling. That ruling upheld liability for financial mismanagement and confirmed provisional damages of at least 250 million guilders, while deferring the final determination of damages linked to unlawful dividend payments, pending an independent valuation of the Mullet Bay property. That valuation process is now nearing completion. Once the final expert report is submitted and debated, the Joint Court will render its final judgment, determining the total damages owed. In short, although the appeal reduced the potential quantum of damages, the core finding of liability against the late Mr. Ansari and his co-defendants has been upheld. What concrete guarantees and monitoring mechanisms are in place to ensure policyholders' interests remain fully protected in the new structure, especially if asset recovery does not meet projections or further legal complications arise? Madam Chair, the new structure of ENNIA remains under the control of the CBCS, as per the court-mandated emergency regulation that granted it the legal authority to take over the administration and eventually restructure the company. This was done primarily to guarantee the interests of the policyholders. The Supervisory Board of Directors of the CBCS is the entity that has the statutory duty to supervise and monitor the management board of the bank. Madam Chair, as part of the ENNIA Outline Agreement, a newly structured insurance group under the name ENNIA New successfully commenced operations as a solvent and independently functioning entity as of January 1, 2025. The new ENNIA is headed by the newly incorporated holding company, ENNIA Holding NV, which owns ENNIA Leven NV, along with the financially stable existing entities ENNIA Caribe Schade NV and ENNIA Caribe Zorg NV. Sorry, my apologies. Do this, sorry. What is the status, my apologies, and what are the expected next steps of any criminal investigations into the former majority shareholder or other responsible individuals, including cooperation with authorities outside St. Maarten and Curacao? Madam Chair, the current status of the ENNIA matter remains complex and is largely tied up in ongoing civil litigation. A key issue concerns the valuation of the Mullet Bay property as at 2009, for which the court ordered an independent appraisal. Media reports referring to a value in the 80 million guilder range are based on what appears to be a draft finding related to that historical data only, or date only. This figure is neither a final court-accepted valuation nor a reflection of the property's current market value. While the expert has reportedly completed a broader report covering several historical valuation dates, the final official valuation for purpose of the court proceedings has not yet been submitted to nor accepted by the Joint Court of Justice. Madam Chair, with respect to other legal proceedings, possible criminal investigations fall under the responsibility of the Public Prosecutor's Office, and my understanding is that these matters are receiving due attention. Outside of St. Maarten and Curacao, the central bank has been actively pursuing several legal actions in the U.S. to recover ENNIA-related assets and to counter claims by the Ansari family. I can inform Parliament that these proceedings have thus far been progressing favorably for the central bank, including successful defenses against counterclaims and key procedural rulings. The primary focus now is before the Texas court, where the central bank is seeking recognition and enforcement of the Curacao liability judgment, which would allow it to pursue U.S.-based assets through the full range of legal collection remedies. Next question. For ENNIA Aruba and the other remaining group entities, what specific strategic options are being considered, and who is providing independent oversight or advice to ensure maximum value for policyholders and the public interest? Madam Chair, strategic options for ENNIA Aruba are indeed being explored that take into account the interests of both ENNIA Aruba and its policyholders, as well as those of the wider ENNIA group and its policyholders. Concretely, Madam Chair, the ENNIA entities in Aruba have been historically more solvent and operate under the supervision of the Central Bank in Aruba, CBA. The CBCS is currently exploring the following strategic options for these financially sound Aruban entities, ENNIA Aruba, which may involve a possible sale to a third party, a reputable buyer, or a structuring or separation to fully insulate them from the liabilities of the old ENNIA group. This process, Madam Chair, involves close cooperation and the signing of protocols between the CBCS and the CBA and the parent company to ensure the interests of Aruban policyholders are safeguarded. Is government oversight of the CBCS's action in restructuring, litigating, and covering ENNIA assets adequate and transparent? What ongoing reporting commitments will the Minister and CBCS make to Parliament between now and the expected final judgment in 2026? Madam Chair, this is precisely one of the main reasons why resolving the issue of the Supervisory Board of Directors is crucial, since it is largely or legally responsible for the oversight which the Honourable MP is asking about. An incomplete temporary SBOD would not seem to be in a position to provide adequate oversight that is required in this case. At present, Madam Chair, independent oversight is provided through multiple layers. One, Supervisory Board of ENNIA New. The board is composed of professional independent members charged with overseeing the day-to-day management and ensuring the new entity operates soundly and sustainably. Two, Regulatory oversight, the CBCS itself remains the ultimate regulator and administrator of the entire resolution process. 3, the judiciary, the entire emergency regulation and all major steps like the partial transfer of policies and the court case have been and remain under the oversight of the Joint Court of Justice of Curacao, St. Maarten, and Aruba. And 4, the governments and parliaments, both the Curacao and St. Maarten governments and parliaments, receive regular briefings on the financial status of the resolution and have approved the outline agreement providing a democratic oversight layer. Madam Chair, now move on to questions posed by the Honourable Member of Parliament, MP La Vega, who asks, what is the difference between old and new ENNIA? Madam Chair, the CBCS was granted full control of ENNIA when the Court of First Instance in Curacao issued an emergency regulation on July 4, 2018. This allowed a restructuring of the company, which resulted in the creation of 2 separate structures to address the financial crisis of the company. This restructuring was formalized on January 1, 2025. The old ENNIA, which is under emergency regulation, consists of Velia NV, formerly ENNIA Caribe Leven NV, and Vehia NV, formerly ENNIA Caribe Holding NV. On the other hand, Madam Chair, the new ENNIA consists of ENNIA Holding NV, ENNIA Leven NV, ENNIA Caribe Scada NV, and ENNIA Caribe Zorg NV. To be clear, Madam Chair, the old ENNIA holds the liabilities accrued from premiums paid before July 4, 2018. Its purpose is to wind down the deficit-ridden legacy portfolios and pursue legal claims against the late Mr. Ansari and other co-defendants, whereas, Madam Chair, the new ENNIA holds the liabilities accrued from premiums paid on or after July 4, 2018. It was established to provide a financially stable, long-term future for the group's active insurance business. What are their ownership and management structures? Through you, Madam Chair, the old ENNIA, the directorate and supervisory board powers of these entities are entirely exercised by the Central Bank of Curacao and St. Maarten under the authority of the emergency regulation. Regarding the new ENNIA, Madam Chair, this group is structured as a sustainable, independently capitalized entity. The CBCS has appointed new professional management and supervisory boards for these entities, which are subject to regulatory approval. Why was the old ENNIA not simply liquidated to give way to the new ENNIA? Madam Chair, liquidation was avoided because it would have immediately triggered massive, devastating reductions, discounts in the pension and life insurance policies of approximately 30,000 policyholders across Curacao, St. Maarten, and other jurisdictions, and would have led to severe social and economic consequences. Madam Chair, the chosen method, a partial restart, served 2 critical purposes. 1, safeguarding the policyholders by transferring the post-2018 premium paying portfolio, the good part, to the new ENNIA. The CBCS ensured that active policyholders have a solvent insurer. 2, financing the deficit. The outline agreement provides a mechanism where remaining deficit in the old ENNIA is financed by long-term contributions from the CBCS and the governments of Curacao and St. Maarten, thereby avoiding any discount on policyholders' rights. Are any St. Maarteners on the boards of the different entities? Madam Chair, as the resolution fund is key towards the payments to the ENNIA policyholders, the construct of the resolution fund board is as follows: 1 member representing St. Maarten, 1 member representing CBCS, and 2 members representing Curacao. What is the total amount CBCS is claiming and how much was collected? Madam Chair, the total amount CBCS is claiming from the late Mr. Ansari and his co-defendants is at present undetermined. This is due to the fact that the court has not yet decided the amount, as it is awaiting an independent appraisal of Mullet Bay, which it has ordered. Concerning how much has been collected so far, Madam Chair, no significant amount of the court-ordered claims have been formally collected or recovered from the late Mr. Ansari and the co-defendants to date. As I stated before, Madam Chair, the recovery efforts are ongoing. These are focused on the complex legal process of domestication and enforcement of the Curacao court judgment in the U.S. courts, Texas, and the court-ordered appraisal of Mullet Bay. If ultimately successful, how would these claims affect the outline agreement? In other words, would the amount each country agree to contribute be lessened? Madam Chair, the outline agreement or the resolution signed by the governments of Curacao, St. Maarten, and the CBCS provides a sustainable solution regardless of the success of the legal claims. By this agreement, Madam Chair, the governments of St. Maarten and Curacao and the CBCS have committed to annual contributions to a resolution fund for many years to fill the deficit and prevent any reduction in pensions. Madam Chair, it is indeed important to stress that any amount successfully recovered from the late Mr. Ansari and his co-defendants will be used to reduce the required annual contributions from the governments and the CBCS to the resolution fund, thereby reducing the financial burden on the countries and the bank. Madam Chair, if you would allow me, I would like to now answer questions concerning Mullet Bay. Both Honorable MP Janssen and MP Kotai asked the following question. Regarding Mullet Bay, the minister mentioned days of litigation, but also St. Maarten holds the right of first refusal. How is St. Maarten preparing to purchase Mullet Bay when the time comes, if there is money? Madam Chair, indeed, the issue of Mullet Bay, which is tied to the ENNIA saga, remains in a complex and lengthy series of litigations, and the Honorable MP is right, or MPs are right. I was able to secure the right of first refusal should the property be up for sale. However, as I explained before, Madam Chair, Mullet Bay is not for sale at present. It is difficult to prepare to buy a property that is enmeshed in court battles and whose actual value and boundaries are yet to be determined. If we were to go by the interim appraisal report of $80 million to $85 million as of 2009, I can safely say, Madam Chair, that government does not have that kind of money right now. The present day value of the property may even be significantly higher. What government is doing, Madam Chair, is to look closely at possible alternative mechanisms to secure Mullet Bay for St. Maarten. This includes a possible public-private partnership supporting a possible local consortium and other modalities. If the funds aren't available, what financial contract would make a purchase possible? Madam Chair, I can inform the Honorable MP and Parliament that I, along with a group of advisors who will be assisting with drawing up a financial mechanism that would allow us to exercise St. Maarten's right of first refusal in the event that the property is placed on the market for sale. I will very gladly welcome the input of Parliament in this process. Madam Chair, MP Kotai also posed several interesting questions about Mullet Bay. He asks, who owns Mullet Bay right now? As far as I know, Madam Chair, Mullet Bay is still owned by Sun Resorts Limited NV, which falls under the old ENNIA entity. What is the objective of the master plan mentioned by the Minister? Madam Chair, Sun Resorts Limited NV, according to my understanding, has decided to develop a master plan for Mullet Bay as owners of the property. According to the company, a master plan for Mullet Bay will provide a structured, long-term vision for the sustainable and commercially successful development of Mullet Bay. The main aspects of this master plan, according to Sun Resorts NV, may include the development of hotels, a golf course, residential areas, marinas, and supporting infrastructure. How can a master plan be drafted when the property boundaries are still unclear? Madam Chair, I honestly don't know. All I can inform the honorable members of Parliament through you is that Sun Resorts itself confirmed that it first needs to have the boundaries of Mullet Bay at the seaside established. It further disclosed that a court case to solve this matter started on August 19, 2025. I do not have any further information about the court proceedings. Why is Sun Resorts NB taking steps regarding the property boundaries? Madam Chair, through you, that is a question that only Sun Resorts can properly answer. What I can say is that it will ultimately be for the appropriate authorities to determine what legally constitutes Mullet Bay when it is placed on the market for sale. Who is legally responsible for determining real estate boundaries on St. Martin. Madam Chair, through you, the legal authority responsible for determining and registering real estate boundaries on St. Martin is the cadastre. In this case, however, certain boundary aspects are disputed, which is why the matter is currently before the court following proceedings initiated by Sun Resorts. If Mullet Bay is sold, where will the proceeds go? Madam Chair, through you, if Mullet Bay is sold, the proceeds would be applied towards satisfying claims in the ENNIA proceedings. This would reduce the financial burden on the resolution fund and consequently lower the contributions required from St. Martin, Curacao, and the CBCS under the outline agreement. Madam Chair, the Honorable MP Peterson had one important question related to Mullet Bay. He asked, are there plans to co-develop Mullet Bay with Sun Resorts to ensure that government's wishes are respected by future purchasers? Madam Chair, no. There are no plans to co-develop Mullet Bay with Sun Resorts. St. Martin's position is clear. Government is not engaging in co-development arrangements, nor is it participating in or financing any master plan with a private party. Our focus is not on development concepts, but on safeguarding the country's legal and financial position. Madam Chair, the outline agreement approved by the parliaments of both Curacao and St. Martin explicitly requires that Mullet Bay be sold, that the proceeds flow directly to the resolution fund to pay ENNIA policyholders. That is not optional. Should the sale not occur, the countries would be required to collectively raise approximately $100 million to fund the resolution fund. Against that backdrop, there is no basis for alternative arrangements that would delay or undermine the sale. What government requires is clarity on when Mullet Bay will be placed back on the market so that St. Martin can exercise its right of first refusal, while zoning and regulatory measures safeguard the national interest. Madam Chair, through you, the Honorable MP Doran, through MP Irion, also posed some important questions. He asked, were provisions made in the 2026 budget to include CapEx for acquiring Mullet Bay? Madam Chair, through you, no provisions were included in the 2026 budget for CapEx related to the acquisition of Mullet Bay. The property is not currently for sale, as court proceedings are still ongoing, with a final decision not expected before the end of 2026 and potentially subject to appeal. Given these uncertainties, it would not be responsible to budget public funds for an acquisition that is neither available nor legally settled at this time. What is the government's vision for the development of Mullet Bay? Madam Chair, through you, as previously stated, during the public meeting of Parliament on October 17th, the governing program of this coalition government explicitly provides that government will assess the potential acquisition of Mullet Bay for St. Martin. That process commenced with ensuring that St. Martin's legal position is safeguarded. First and foremost, by securing the right of first refusal should the property eventually be offered for sale. Mullet Bay has historically been a cornerstone of our tourism economy, and government's vision is to see it started as an asset that serves the people of St. Martin. Within the bounds of the law, existing agreements, and financial responsibility, the Ministry of Finance will continue to do everything within its power to ensure that Mullet Bay ultimately benefits the people of this country. Why isn't government more directly involved in the master plan, and can a timeline and step-by-step plan for the acquisition be provided? Madam Chair, the question has been put forward reflects certain assumptions that I do not fully share, and it is therefore important for me to clearly state my position. It is my view that Sun Resorts, in an effort to remain relevant, is advancing a master plan and seeking to involve government as a stakeholder. However, experience has shown that when we operate outside established frameworks, we invite unnecessary complications. Mullet Bay has or was previously placed out to bid. What was the result of that bid? Then there came multiple court cases, the effects of which we are still addressing today. It is precisely because of the amended outline agreement that St. Maarten still has a realistic opportunity to acquire Mullet Bay. Without it, we could have effectively lost this asset altogether. Madam Chair, under that same outline agreement, it is clearly established that the resolution fund exists to ensure ENNIA policyholders are paid, that all proceeds from court cases, including the sale of Mullet Bay, flow to that fund, and that St. Maarten is not contributing to any operational costs relating to the fund or to any proposed master plan. Our interest at this stage is therefore clear and limited. We need certainty on when Mullet Bay will be placed back on the market so that our right of first refusal can be exercised, while zoning measures take effect to protect the national interest. This approach safeguards St. Maarten legally, financially, and strategically, and ensures decisions are made responsibly and in the best interest of our people. Madam Chair, the Honourable MP Lewis also had a simple but profound question about Mullet Bay. He asked, how hard are we fighting for Mullet Bay for the people of St. Maarten? Madam Chair, this question goes to the very heart of why we are here today, to safeguard Mullet Bay in the interest of the people of St. Maarten. This is not about confrontation, but about shared responsibility for an asset of national importance. I want to state clearly that I am fully committed to protecting Mullet Bay as part of our national patrimony, and I have dedicated significant time and attention to this matter because of its long-term value to our country. The commitment remains resolute. Through you, Madam Chair, safeguarding Mullet Bay is not the responsibility of one minister or one institution alone. It requires cooperation and alignment between government and parliament. I therefore call on all members to stand together in defense of St. Maarten's national interests so that we arrive at outcomes that are lawful, sustainable, and in the best interest of our people. Madam Chair, this concludes my responses. I thank the honourable members of Parliament for their engagement and remain available for any further questions. Thank you.
Thank you, Minister, for those responses to the questions by members of Parliament. Of course, now members have the opportunity, if the need is there, for the Minister to clarify any of the answers given. Does any member have the need for a clarifying question? We do have MP York. MP York, I give you the floor to ask for your clarification. MP York.
Thank you, Madam Chair. And once again, thank you to the Minister for her answers and elaborate explanations. I appreciate it. Madam Chair, I have a series of clarifications that I would like to pose to the Minister. So I would like to ask for your indulgence. Madam Chair, one thing I agree with the Minister on today is the fact where the Minister stated that conditional appointment and conditional nomination are not synonymous to one another. So I agree with the Minister on that. However, my queries were not based on a conditional appointment versus a conditional nomination. They were based on conditional nomination versus nomination, all right? So while listening to the Minister and some of the explanations, and I will get to my clarification question right now, Madam Chair.
Also in the interest of time and considering that we have a meeting at 3 o'clock, so I wanted to get whatever clarifications in as quickly as we can in order to then basically continue with the meeting that we have at 3 p.m. So if you would just formalize and finalize your clarifications as quickly as you can, please.
Madam Chair, I understand that, but seeing that we've waited 2 months to have this moment with the Minister, I don't think we'll be doing the people justice. But this is only clarifications,
member. You'll have the opportunity following the Minister's responses. We'll go in, we have to go into a second round as well. So clarifications at this point in time. MP York, you may continue.
Moving on. Thank you, Madam Chair.
You're welcome.
So as I was saying before I was explained by the chair lady how she would like the clarifications to run. As I was saying, there were some things that I listened to the minister speak where she said, I do not believe that in explaining why the legal affairs was not involved, she said, the minister stated, I do not believe that the nomination is a legislative manner, and explaining why it came to COM, she explained that it was merely for that the COM merely had to approve the nominee recommended by her person. So I would like the minister to clarify exactly the difference between the conditional nomination, seeing that there's no legal basis for it, and the words that she used, and I'm sure if she could look at it in her notes, that she used the word nomination. So if she can clarify that. Also, I would like the minister to clarify if the advisors that she referred to, that were not the committee, but the minister used the word advisors, if they were employed or are employed by the cabinet or by the government. If the minister can clarify that. Also, the minister stated that the advices could not be shared with Parliament at this time. At this stage, I would like the minister to clarify what stage is she referring to, because we are referring to a stage that, in my estimation, has already passed. That's concerning the former nominee, not the future nominees. So which stage is she referring to? And can she again, the minister, Madam Chair, clarify what did she mean by the documents being confidential to Parliament? I understood the minister explained it twice, but if she can explain it more in layman's terms what she meant by that, I would appreciate that very much. Also, the accuracy in the statements made by the former nominee in court. The minister stated that she cannot confirm nor deny those statements, and that she's not aware of those statements, but can the minister clarify if she made any attempts to find out the legitimacy of those statements, seeing that the court case is public and the notes of the court the proceedings can be requested. And seeing that we still have to go into a second round, that would be it for my clarification questions. Thank you.
Thank you, MP York. We now continue with clarifications, and MP Doran has the floor for clarifications. MP Doran, you have the floor.
Thank you, Madam Chair, lady. Good afternoon to you, my colleagues, and the minister once again. Madam Chair, through you, based on my interruption a while ago, I delved into the point where the candidate at the time, Mr. Bloom, mentioned in court in front of me, in front of MP York and everybody else that was in the room, that he read his own advice. The minister stated here that there was a leak by COM, the Council of Ministers, because before the Council of Ministers meeting ended, the minister received messages on what was just discussed. I also inquired if there was an investigation that was ongoing, and it was mentioned that there was no investigation ongoing. My question through you, Madam Chair, to the Honorable Minister of Finance, do you intend to conduct an investigation, or does it not matter if your colleagues and or maybe staff are leaking information? And I use that very lightly because, I mean, clearly we know that there were some ministers against it publicly as well. So therefore, I'm not going towards the direction of the staff at all, but I'm just naming the facts of the prospective culprits. Through you, Madam Chair. So that's my first clarification. Secondly, Madam Chair, I would like to know, based on the Mullet Bay point that was just brought forward by the minister, I would like to know, Minister, through you, how can you then work on securing the first right of refusal when you don't make provisions in the budget? I know this question seems a bit redundant over and over, but still I can't get a clear answer. We say that we're securing the first right refusal, but we're not making no budgetary provisions in order to, if we find ourselves in a position to have some kind of money to secure it. How can you secure Mullet Bay without making any budget provisions? Secondly, Madam Chair, I heard the minister mention that they're going to do everything in their power to benefit the people of St. Maarten when it comes to the sales and purchase of Mullet Bay? Madam Chair, this question is very blunt. Minister, through you, Madam Chair, do you intend to make sure everybody benefits in St. Maarten or some people? Thank you.
Thank you, MP Doran. I don't see any other member of parliament requiring the floor for clarifications. I look to the minister. Minister, you have a few questions for clarifications. Would you like to go into those answers now? Do you require a few moments? And you too, Minister, I would remind of our meeting, a meeting of Parliament at 3 p.m. So, Minister, you may respond to my question in terms of your responding to the clarifications. Minister?
Thank you, Madam Chair. Although it was just a few clarifications, I would need some time, Madam Chair, to respond to those questions. I don't know, knowing the time that you have a 3 o'clock meeting, if it would mean then I am back here tomorrow, so hopefully then maybe tomorrow, if that's possible.
Thank you, Minister. That is noted, and we will see how we can schedule the continuation of this meeting. I agree with you. It should be as soon as possible. And if any possibility for this meeting, and this is towards the members of Parliament, to continue tomorrow, then that will definitely be entertained. Until that time, I want to thank you, Minister, and your support staff for your presence here today, members of Parliament, for your continued interest in this matter at hand. And I would hereby adjourn this public meeting of Parliament until further notice, and hopefully that can be as soon as possible. This meeting is hereby adjourned.